Greetings! I'm Zachary Hepner. I'm pleased to share this Dvar Torah with you for Parashat Noah. While the Roe V. Wade decision in 1973 was about abortion and the sovereign rights of individual states, the legal history of abortion in the United States predates the 1970s by over a century. The Comstock Law of 1873 was a federal law that made it a crime to sell or distribute materials that could be used for contraception or abortion. I claim that the legality of this issue might go back to our founding father, in particular, James Madison, the composer of the Fourth Amendment, which was introduced in 1789. The backstory of the Fourth Amendment grew out of the colonial experience against the government's use of writs of assistance. In the earliest case, Semayne's case in 1604, Semayne sued for damages against the London sheriff who broke in and entered his house to collect against Peter Semayne's debts. Then in 1864, Attorney General Sir Edward Coke cited a common law statute enacted by King Edward II of 14th century England that, quote, in all cases when the king is party, the sheriff may break the party's house, either to arrest him or to do other execution of the king's process. If otherwise he cannot enter, but before he breaks in, he ought to signify the cause of his coming, and to make request to open doors. End quote. By 1763, the maxim that every man's house is his castle was taken literally and was used by William Pitt in Parliament. Quote, the poorest man may in his cottage bid defiance to all the force of the crown. It may be frail, its roof may shake, the wind may blow through it, the storm may enter, the rain may enter, but the King of England cannot enter. All his force dares not cross the threshold of the ruined tenement. A more relevant case that led to the introduction of the Fourth Amendment was in 1765, Entick versus Carrington, a civil action against state officers who had raided many homes, connected to the possible possession of polemical pamphlets composed by John Wilkes, who had attacked government policies and the King of England. Thus began the winning battles of individual liberty and privacy. Fast forward to 1789, with James Madison's Fourth Amendment, which I quote here, quote, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized, end quote. Now that we have given a very brief backdrop of the Fourth Amendment, let's backtrack a bit and talk about the fourth President, James Madison. Born in Virginia, 1751, by 16, Madison had learned mathematics, geography, and modern and classical languages, with proficiency in Latin. At age 16, Madison returned to Montpellier, where he studied under the Reverend Thomas Martin to prepare for college. Unlike most college-bound Virginians of his day, in 1769, he enrolled at Princeton, then formerly named the College of New Jersey, where he studied Latin, Greek, theology, works of the Enlightenment, with an emphasis placed on speech and debate. Madison had contemplated either entering the clergy or practicing law after graduation, but instead remained at Princeton to study Hebrew and political philosophy under the college's president, John Witherspoon. He returned home to Montpellier early 1772. It's of critical importance to emphasize that Madison had taken his studies in pursuit of becoming a proficient Hebraist because, in addition to studying the Hebrew scriptures, he would have taken particular interest in Babylonian Talmud, Masechet Sanhedrin 57. There are 2,711 pages in Talmud Bavli. Of those, some would be of particular interest to Gentiles because the law of Gentile, or the 7 laws of Noah, are contained in the 4 pages of Sanhedrin 56 and 57. Yaakov Elman has observed that the many of the Amoraim who are central to these pages are Mechozen, Jews from the Persian metropolis city of Mahoza. It makes sense that these rabbis would have been particularly interested in discussing a traditional view of their relationships with their Gentile neighbors and how their neighbors could observe what is today called the laws of Noah. Sanhedrin 57 not only enumerates the prohibition against murder for a Gentile as a capital crime, as prescribed in the Noah post-flood pericope, Genesis 9, but Sanhedrin 57 fills an additional lacuna. Shofech dam ha'adam be'adam damoy shafech. Mishum Rabbi Yishmael amru af al ha'ubrin. My time at Rabbi Yishmael dichtiv shofech dam ha'adam be'adam damoy shafech. Ezu hu adam shehu be'adam. Havi omer zu ubar shebemei imo. I quote Zephariah. A descendant of Noah is executed even for killing fetuses. The Gemara asks, what is the reason? It is derived from that which it is written. One who sheds the blood of a person, by a person, ba'adam, his blood shall be shed. The word ba'adam literally means in a person and is interpreted homiletically. What is a person that is in a person? You must say this is a fetus that is in its mother's womb. Contemporary rabbis, such as the most famous rabbi antagonistic to abortion for non-therapeutic measures, Rabbi Moshe Feinstein, this begins and ends the conversation about abortion, with exceptions only for cases of medical rodef statuses or required medical interventions. Abortion is a prohibition under the category of murder, full stop. Even for the most famous lenient contemporary rabbi, Rabbi Tzitz Eliezer Walderman, any permissive reason is despite the Adam, be'adam wordplay, not because of the wordplay. Gentile Hebraicists have a legacy of studying Hebrew scriptures. For those who would have been interested in rabbinic texts or how the rabbis viewed the other in a legal sense, Sanhedrin 56-57 is possibly the most relevant snippet of Talmud to study and the most likely primary source to have gained familiarity. The 17th century Cambridge Hebraist John Selden developed De jure naturalis et gentium juxta disciplinam eborarium, the thesis that the 7 Noahide commandments constitute a highly developed doctrine of natural law. I quote Eric Nelson on page 114 of the Hebrew Republic. Quote, Selden owes all of this to a rabbinic literature, specifically to the canonical account in Babylonian Talmud, Sanhedrin 56, and its elaboration in Maimonides' Mishnah Torah. End quote. Let's read the first half of the Fourth Amendment one more time. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, etc. The right of the people to be secure in their persons. This is an oblique reference to people who are currently secure in their persons. The Constitution is providing people in their persons, fetuses, the right to be secure against unreasonable seizures, and they shall not be violated. The pshat of in their persons is that a person's body shall not be violated. For example, protecting anti-vaxxers against receiving any forced vaccine. But James Madison could have chosen other synonyms, such as bodies, self, or some other word. But instead, he chose a term that he himself could have already gained familiarity with, namely person. Noah Feldman of Harvard, in email conversation, when asked if Madison could have studied Talmud, replied, nope. He said later in life he had learned a bit of Hebrew at Princeton, but definitely not Talmud, end quote. That does not discount the possibility that Madison was familiar with secondary rabbinic sources, such as Maimonides, or the Latin writings of Selden, or other Hebraists, but it does put a limit on the scope of Madison's knowledge of original sources. Philip Hamburger of Columbia, in personal conversation, rejected the entire suggestion as implausible. However, even as a far-fetched suggestion, We may never know with absolute certainty whether James Madison didn't have Sanhedrin 57 in mind when he introduced the Fourth Amendment. But if there ever was a founding father who could have, it would have been him. The true and nuanced meanings of written legal opinions will always be subject to misinterpretation, because that is the nature of Torah shebichtav, that by nature it is inherent to written language. That written word is subject to ambiguity, in sharp contrast to Torah shebe'al peh. If you want a pleasant and easy conversation, talk about the weather, not politics or abortion. Enjoy the food for thought, and wishing you all a Shabbat Shalom.